When people think about succession planning in a family business, they usually think about the obvious assets, the business premises, the bank accounts, the shares, the equipment. And so what if I told you that one of the most valuable assets in the business often isn't listed on the balance sheet at all? It's the intellectual property. I mean, if you're listening to this podcast, you're probably already familiar with that, but go with me. And if nobody has thought about who actually owns it, succession or continuity planning can become very messy very quickly. In the last episode, Sarah Carey and I discussed the Victorian Supreme Court case of the Re Estate of Vaughan, where the executor found himself personally liable after disposing of papers that may have contained valuable robotics intellectual property. That case reminds us that intellectual property doesn't disappear when somebody dies. Today, I want to take that one step further. What happens when all the IP is tied up in a family business? Who actually owns it? And what happens if the founder dies, retires, or sells the business? Let's take a look. Welcome back to Elise Explains IP. I'm Elise Steekstra, intellectual property lawyer and trademark nerd. This podcast is all about making intellectual property practical for business owners and entrepreneurs, because your business is probably creating valuable IP every single day, even if you don't realize it. And when succession planning comes into the picture, ownership suddenly matters a lot. And actually go and get your succession plan done sooner rather than later. When people hear intellectual property, they often picture inventions or patents. But for most family businesses, the valuable IP looks much more ordinary. It might be the business name, the logo, customer databases, recipes, manufacturing processes, software, training manuals, supplier relationships documented in systems, product designs, marketing material, photographs, websites, and even the social media content. Sometimes the family's reputation itself becomes part of the goodwill attached to the business. Over decades, all of these things can become incredibly valuable. Yet surprisingly, few businesses ever have documented who owns them. This is probably one of the biggest issues that I see regularly in small to medium enterprise. Even big businesses gets it wrong sometime. But people often assume I started the business, so now I own everything. Not necessarily. Ownership depends on who actually created the work, under what circumstances, and whether the rights have been assigned. Let's look at a few examples. Perhaps your daughter designed the logo while studying graphic design at university. Your son, who's a tech head, built the website. Your spouse writes all the marketing material. A contractor developed your booking system. And then an external marketing agency created your advertising campaign. Each of these situations has different legal consequences. Simply paying someone doesn't always mean you own the intellectual property that they created. The company doesn't automatically own everything either. This is another trap. Many family businesses trade through a company, or perhaps through a trust that trades through a company. The family assumes the company owns everything. And sometimes that's true. But sometimes it isn't. Perhaps the founder registered the trademark personally 20 years ago and never assigned it to the company. Perhaps the domain name is still registered in mum's personal name. Perhaps the copyright in the operating manual was never assigned to the company. Perhaps important software licenses belong to an individual family member or are being paid for on their personal credit card. These issues often remain hidden until somebody dies, retires, or there's a dispute. Succession planning isn't just about the shares. Here's something I often explain to clients. Owning the shares in a company doesn't necessarily mean every asset connected with the business automatically belongs to the company. If valuable intellectual property is sitting outside the company, you've got a problem. Imagine inheriting a manufacturing business, only to discover the trademark is owned personally by your late father. And the software license can't be transferred without consent. The domain name has expired because nobody knew whose email address had been used to sign up for it. The operating manuals were written by a consultant who never actually assigned the copyright. These aren't hypothetical. Versions of these issues happen regularly, even to big multinational companies. If you want another look at that issue, check out episode 4 of the podcast about craft and bigger. So, what are the hidden risks during estate administration? This links back to the Re Vaughan discussion. Executors have a duty to identify and protect estate assets. That includes the intellectual property. Sometimes they won't even realise that it exists. They might focus on bank accounts and property while overlooking the trademarks, the copyright, registered designs, patents, licensing income, royalty agreements, domain names, digital assets, and confidential know-how. Some of these assets can lose value very quickly if they aren't properly managed and taken care of. Trademarks need renewing. Admittedly, that's every 10 years, but that could be sooner than you think. Domains need renewing a lot more frequently. Licenses may require consent before assignment. Some rights can generate ongoing royalties that need to continue to be collected. IP needs active management. One thing that I see repeatedly is that family estate disputes are rarely just about money. They are often about control. They are also often about personal issues relating to the family. They're also about who gets to keep using mum's business name, who owns grandpa's recipe, who can keep using the family name as a brand, who owns the social media accounts with 100,000 followers, who controls the customer database. If ownership was never properly documented, these questions become much harder and much more expensive to answer. So, what are some practical steps that every family business should take? The good news is that these issues are usually preventable. Here are 5 things every business, and particularly a family business, should do. First, identify your intellectual property. Make a list of everything that is valuable, that is intangible. Secondly, don't assume who owns it. Confirm. Check the legal ownership. Third, make sure the ownership matches your business structure. If the company should own the trademarks, make sure it actually does. And if it should be owned by the trust, make sure that it licenses it to the company. Fourth, document assignments properly whenever someone creates new intellectual property for your company. And finally, include intellectual property in your succession planning conversations, not just in your will, not just in your shareholder agreement, not just in your buy-sell arrangements. Think about who will own, who will manage, and who will control these assets in the future. If you'd like a simple way to start work on this exercise, you can download my free intellectual property audit checklist from my website. It covers many of these questions that we've discussed today and will help you at least start to identify the IP assets that your business already owns or should own. It only takes a few minutes to complete and can uncover those issues before they become expensive problems. Family businesses often spend generations building something extraordinary. The business becomes part of the family's identity. But intellectual property can easily fall through the cracks because it is invisible, it's intangible. You can't walk through a warehouse and point to a trademark. You can't hold the copyright in your hands. Yet these assets may be among the most valuable parts of the business. The Re Vaughan case reminds us that intellectual property most often survives its creator. Today's episode is a reminder that family businesses, small to medium enterprise, all need to know exactly where that intellectual property sits before succession occurs, not afterwards. If you're part of a family business, here's a challenge. Ask one simple question. Who actually owns our intellectual property? If nobody can confidently answer that question, now is the perfect time to find out. Because it's much easier to fix ownership today than during an estate administration or a family dispute. Once you've worked through the checklist, if you'd like some help reviewing your business's IP ownership or incorporating it into your succession planning, you can book a strategy call through the link in the show notes. And thank you for listening to Elise Explains IP. If you've enjoyed this episode, please subscribe, leave me a review, and share it with somebody involved in a family business. Until next time, I'm Elise Dijkstra, helping you protect what you're building. Thanks for spending time with me on Elise Explains IP. If you picked up something useful, hit follow, subscribe, leave us a review, or send it to a founder friend who could use this information. And remember, this is general information, not legal advice. If you do want help with your IP, you can book a strategy call with me at any time via my website. The link's in the description. So until next time, own your own ideas.